2023.
WPS number 4073 of 2023. Learned Counsel for the petition seeks permission to withdraw this writ petition. Learned Counsel for the respondents has no objection to the prayer for withdrawal. Considering the prayer, this writ petition is dismissed as withdrawn.
For final disposal attitude, WPS 7162 of 2023.
Petitioners are the para teachers, my lord, who appeared in a salary incremental examination, my lord, conducted by the JAG, my lord. The grievance of the petitioners are limited to one question number, my lord, that
Where is your technical report?
My lord, we have filed this, the counter affidavit.
Yes.
We filed the report.
What is this? What kind of counter affidavit do you file? You have not annexed a copy of the technical report also?
I will do that.
You see, there is a technical report. We can't do anything about it. But you will get a copy of that through the supplementary.
I have two judgments, madam, in my favor, lordship. If lordship can.
Judgments means for what?
For interference of judicial, my lord, in cases where if lordship can permit.
No, you just tell us what judgment. The technical report can be scrutinized by this court.
No, not technical report,
Then?
my lord. If my lord, if the candidates demonstrate whether that particular answer is right, that the court can interfere.
No. When there is a technical, I am making it very, very clear to you. When there is a technical report, I will not interfere. Counsel for the parties are present. Counsel for the respondent. Who has filed this affidavit? Jack.
Jack.
Yes, Your Lordship, we have filed it.
Respondent Jack is directed to file a supplementary counter affidavit annexing a copy of the report mentioned in paragraph 10 of the counter affidavit. The supplementary affidavit be filed by next Friday. Pose this case on 18th. फाइल में तो कुछ लिख के लेके आए थे.
For press filing item 3, WPS 106 of 2023.
Yes, petitioner.
Yes, I need one thing. In this case, public provision है. Earlier court has passed the order also.
It is an appealable order?
Yes, no, this is a only this honorable court order. If you don't make a, this will also find a 6th petition in this case.
My lord, difference between that case and this case, my lord, I have challenged the jurisdiction because
Jurisdiction of?
the jurisdiction of my appointing authority has not passed the disciplinary action. Severe reprimand order of punishment was given and 1 year in.
You can't raise this plea in the appeal.
The jurisdiction is the
jurisdiction.
point. Lordship, no, it at any stage.
That's right.
If
So
the question of jurisdiction comes.
No, so all the circulars and everything is required to be taken into consideration. If the disciplinary authority has not passed the order and the jurisdiction has not been properly exercised, this can certainly be subject matter of consideration before the appellate authority.
Lord, same and similar matter of this the petitioner. Lord, on 19 February 2024,
Yes.
WPS 109 2023, Your Lordship asked for counterfeit. Then the
Maybe.
counter
No.
come and then, my Lord.
No, not
Your
required.
Lordship,
Not required. So you are
In the other matter is also lodged in a pending laws.
this
Dominica Pipkin.
so he has been filing.
The order 6 petition sales filed order. In the
And the impugned order is the
All
order
the
passed by
cases
the
will not
by
be
the.
severe reprimand.
yes.
देखिए WPS number 106 of 2023. Learned counsel for the parties are present. The state petition has been filed for the following relief. The learned counsel for the respondents has submitted that the impugned order, the petitioner has an efficacious alternative remedy of appeal, and therefore this petition may not be entertained. At this, counsel for the petitioner has submitted that the petitioner has challenged the jurisdiction
of the disciplinary
of the disciplinary authority, and therefore this
who is
petition.
much below the
That's
rank
right.
of the appointment.
That's right. And therefore this
And
petition
one more point.
may be entertained.
The inquiry officer who has given the charge, he has also suggested for punishment.
There is no jurisdiction.
And
has been
the
checked.
learned counsel also submits that the punishment was also suggested by the inquiry officer and he had no jurisdiction to use. After hearing the learned counsel for the parties and considering the nature of relief sought for in this petition, this court is of the considered view that the point of jurisdiction will itself be a mixed question of law and fact, and such matter can be hesitated by the petitioner before the appellate authority. Accordingly, this
I may be allowed to file reference
Yes.
representation
uh,
along with the
considering
order.
सर प्लीज ऐसा आप इतना सीनियर एडवोकेट है डिक्टेशन के बीच में क्यों आप इस तरह से इंटरप्रेट करते accordingly this petition is disposed of, enabling the petitioner to file his appeal within a period of 1 month from today. And it will be open to the petitioner to raise all points which have been raised in this writ petition as well.
Disposed.
Disposed of. Next.
Your ladyship, may I mention, in serial number 2, your ladyship has directed to bring the original records through supplementary affidavit.
Not the original record, the report of the expert committee. It is not a secret document. File it on affidavit.
Your lordship, it is a sealed cover.
Sorry?
Sealed cover.
Why sealed cover? Petitioner has got a right to know. It is not a secret document. You have taken an opinion from an expert. Bring it on record. एक नंबर से वो पास फेल हो रहा है. This is so very important. Yes.
Item 4, WPS 147 of 2023.
Please, Your Lordship. So the prayer in this writ application, Your Lordship, is issue the direction upon the respondent to restore the original post of the petition, Your Lordship. And draw the attention of Your Lordship that annexed 4.
So serial number 2.
Serial number 4. Your Lordship.
Item 4.
Item 4, WPS 147.
Yes, Your Lordship.
What is your prayer?
The prayer in this writ application, direction upon the respondent authority concerned to restore the original post of the petitioner, Your Lordship. Thus, I want to draw the attention of Your Lordship at
No, this is by virtue of a settlement arrived at between the parties.
Parties.
No, nothing. There is a settlement between the parties. And this particular order has been passed by virtue of a settlement. The matter ends.
But Your Lordship, the order.
There is no merit. The learned counsel for the parties are present. The writ petition has been filed for the following relief. The learned counsel for the respondents, while objecting to the prayer made by the petitioner, has submitted that where is the order of settlement in your counter affidavit? Yes. Has submitted that the petitioner was reinstated in service as a fresh employee by virtue of office order dated 31/5/2022, which was a settlement arrived in terms of as per the terms and conditions in Form H of Industrial Disputes within brackets Central Rules, and was duly signed by both the parties. The learned counsel has submitted that such settlement is binding, and the petitioner has also acted pursuant to that settlement, and therefore it is not open to the petitioner to challenge the same. After hearing the learned counsel for the parties and considering the aforesaid facts and circumstances that there has been a settlement between the parties, and the petitioner has joined the post pursuant to such settlement, this court is not inclined to grant the relief as prayed for by the petitioner, and therefore this petition is hereby dismissed. Next. This one.
Item 5, WPS 1006 of 2023.
Petitioner,
Lordship, I am grants or pass out. Lordship.
okay, pass over next.
Item 6, WPS 1033 of 2023.
Yes, petitioner. The file, मेरा note है इसमें. Yes, madam.
May I please, Your Lordship, Ladyship. This is the second round of litigation, Your Lordship. Annexure 4, page 18 is the order passed by this honorable court earlier. And
Yes, ma'am.
subsequently,
Annexure 4 was just an order for disposal
yes,
of
yes,
representation.
and subsequently Annexure 5, page 20 has been passed, rejecting the claim of the petitioner.
What
Your
is the
Lordship,
ground of challenge?
The ground of challenge are three, threefold, Your Lordship.
Yes.
The petitioner was appointed in the year 1988, Your Lordship, and during the his service career, he was granted only one upgraded pay scale of grade 2, Your Lordship. He was not granted grade 4, 7, which has already been rejected.
Your
by
annexure number is, which is under challenge is
Annexure 5.
There is no annexure file. From where did I get this? I want the entire file at one go. You have to open the entire file at one go, like this one. Okay? Annexure file. Where is annexure file? I don't get it. This is annexure. No, annexure. What is the date?
This is dated 23/10/2021.
This one. Where is it? Not there in this scan. This scan is not properly done. Right? Are we able to get this document? This one? Adesh? No, it's not there. No, the scan is not, has not been properly done. Yes.
So relevant would be page 21, Your Lordship, that down for rejection.
Yes.
Second para, Your Lordship.
No, you please place it.
Pura-
Para number, you just tell us that what is the illegality and,
That is what I am bringing on.
okay, page
Your
number
Lordship.
20, last portion.
21.
Page number 20 starts from page. Yes.
शिक्षकों के प्रोन्नत के संदर्भ में विभागीय नियमावली आदेशों प्राथमिक विद्यालय शिक्षक प्रोन्नति नियमावली 1993 के आलोक में यह स्पष्ट है कि ग्रेड 4 एंड ग्रेड 7 दोनों पद प्रोन्नति पोस्ट प्रमोशन है तथा ग्रेड 4 प्राप्त स्नातकोत्तर बी ग्रेजुएट शिक्षक को उपलब्ध ओटीवार रीति अनुसार ग्रेड 7 में प्रोन्नति दिए जाने का प्रावधान है। तदनुसार वादी को सेवानिवृत्ति उपरांत कोई भी पद प्रोन्नति या ग्रेड 4 में प्रोन्नति मान्य नहीं है।
Yes.
नियमानुसार पद प्रोन्नति 4 एवं 7 प्राप्त शिक्षकों को विद्यालय व निर्धारित रिक्त के विरुद्ध पदासीन होने के उपरांत ही निर्धारित वेतनमान देय है। उपरोक्त तथ्यों अभिलेखों विभागीय नियमों एवं न्यायाधीश के आलोक में पाया गया कि वादी श्री सुरेश चंद्र मेहरा सेवानिवृत्त शिक्षक के समतुल्य कोटि के किसी अन्य शिक्षक जिनका वर्ष 2009-10 में जिले के शिक्षकों को ग्रेड 4 प्रदान करने हेतु निर्मित वरीयता सूची में नाम अंकित किया गया हो, परंतु सरकार द्वारा स्वीकृत कोटिवार रिक्ति के विरुद्ध प्रोन्नति हेतु रोस्टर बिंदु अनुसार जिला शिक्षा स्थापना समिति देवघर द्वारा सभी रिक्तियों पद के विरुद्ध प्रोन्नति प्रदान करने के उपरांत निम्न वरीयता क्रम में रहने के कारण प्रोन्नति प्रदान नहीं की जा सकी हो, वैसे किसी शिक्षकों को ग्रेड 4 में प्रोन्नति इस जिले में नहीं दी गई है। So no promotion was
No,
done.
no, no. Any person who has been junior to you has not been promoted.
Your Lordship, my content, that is my case
No, this
also.
Who is the person junior to you who has been promoted? Give
No,
me the
no
name.
one has been granted promotion.
No
That
one
is
has
my
been
case.
granted promotion.
Yes,
No,
Your
that
Lordship.
is not the साथ ही ग्रेड 4 में प्रोन्नत ग्रेड 4 में शिक्षकों के पदासीन होने के that is a separate promotion has been given.
नहीं, वैसे किसी शिक्षक को ग्रेड 4 में प्रोन्नति इस जिले में नहीं दी गई है.
That's right.
So no.
Is it your case that nobody has been promoted?
Yes, Your
Show
Lordship.
us from the writ petition that your case is that nobody has been granted promotion. And second is whether you are entitled to promotion even after retirement.
Your Lordship, I'll be only entitled for the notional
No,
promotion.
no.
Because if
Promotion is not a financial upgradation. You are not entitled to promotion unless you actually join the promoted post. You show us that no promotion was ever granted. And what is the date from which you are seeking promotion? And what is the date of your retirement?
my date of retirement is, Your Lordship, 28/11/2020.
2020.
And
Okay.
I filed the earlier.
You are seeking promotion to which grade now?
On grade 4 and 7, Your Lordship.
Grade 4
And 7.
and 7.
I would
4
be
from which date?
that is, Your Lordship, 2009-10.
No, grade 4 you are seeking for 2009-10.
Date I have not been given.
You file a no. Unless you join the promoted post, there is no question of granting any kind of notional benefit. WPS number 1033 of 2023. Counsel for the parties are present. Upon going through the impugned order as contained in Annexure 5, this court finds that as per the impugned order, no person junior to the petitioner has been granted promotion. Further, it appears that the petitioner has attained the age of superannuation on 28/11/2020. This court is of the prima facie view that the question of any notional promotion does not arise after the petitioner has attained the age of superannuation, and the writ petition does not reveal as to the date from which the petitioner is seeking promotion to grade 4 and grade 7. The learned counsel has submitted that promotion का तो सारा बात आप बता रहे हैं writ petition में. You say that no promotion was granted.
To anyone.
No, you are saying while passing the order ought to have been reserved for scheduled caste. You are just referring, it appears that promotion has been granted. Upon this, counsel for the petitioner prays for time to file a supplementary affidavit in the present case. How much time do you need?
4 weeks.
Let the supplementary affidavit be filed by 4th of April. Post this case on 8th of April under the same heading. Next.
Item 7, WPS 1083 of 2023.
Yes, petitioner. What is it? Where is the petitioner? What was the age of the petitioner on the date of death of his father? 7 years. What is the date of death? What is the date
At
of
the time
death?
of filing, Lord, it
Where
has
is-
mentioned 25 years. Lord.
Had you forget about it, you have not seen the records. You just come to
दो 2006 में डेथ हुआ है. अभी ये बोल रहे हैं कि 25 साल के हैं, तो उनका हो गया वो जो 6 साल के करीब हो। 7 साल।
What is the date of death?
25/9/2006
25/9/2006. This was and when did his brother die?
The brother died in 30/5/2011.
Where is the petitioner? There is one document. Yes, you come to Annexure 4 series. Online में थोड़ा सा टाइम लग रहा है, but I will shift to online very soon. I'm trying to. Yes, no, sorry, you come to page number 29. The petitioner who is seeking appointment is petitioner number 4. Correct? Neeraj Kumar Das. He was 10 years on 24/1/2007. Is that correct? सही बोल रहे हैं कि गलत बोल रहे हैं? Petitioner नहीं है, so you have more responsibility. You have got page number 29, Annexure 5.
Page number 29.
Right? Neeraj Kumar Das, 10 years.
ये हुजूर ये इशू हो रहा है अंचल अधिकारी का हुजूर डेट देखा
2007 में
2007।
नीरज कुमार दास का कितना उम्र बता रहे हैं?
लेकिन हुजूर ये जो
अभी थोड़ी चलते रहेगा क्या जीवन भर? He is seeking compassionate appointment against his father who died in harness in the year 2006. And in the meantime, his brother had applied, and then in the meantime, he also died.
उनका तो रिजेक्ट हो चुका है।
नहीं, he reject नहीं हुआ था, उनका death हो गया।
I have annexed with the counter affidavit.
Okay. His case was rejected.
Yes.
Now, under what circumstances he can claim?
But we are opposing him. We are opposing.
Learned counsel for the petitioner is absent. The learned counsel for the respondent submit that the father of the petitioner had expired on 25/9/2006, right?
Yes.
And thereafter his brother, namely Manoj Kumar Das,
Manoj Kumar Das.
had applied for compassionate appointment, and his claim was rejected by order dated
Blood meeting dated 11/10/2011.
by meeting dated 11/10/2011, and prior to such rejection, he also expired on
But he expired on 30/5/11.
30/5/2011, and thereafter the petitioner is seeking compassionate appointment. The learned counsel submits that the petitioner has moved this court in the year 2023, and his brother had expired on 30/5/2011, and further, as per Annexure 5 dated 24/1/2007, which was issued after the death of his father, the petitioner was 10 years of age. The learned counsel submits that much time has elapsed, and therefore the petitioner is not entitled to any relief. after hearing the learned counsel for the respondents and considering the materials on record, this court finds that even as per the writ petition, the father of the petitioner had expired on 25/9/2006. His brother, Manoj Kumar Das, who was 17 years of age as on 24/1/2007, as per Annexure 5, had applied for compassionate appointment, and his claim was rejected by order dated 11/10/2011, but prior to that, he expired on 30/5/2011. Thereafter, the circular was issued by the state government in the year 2015, wherein the brother was also entitled for compassionate appointment.
But that notification is applicable from the date of
Yes.
its issuance.
Please hold on. The Annexure 5 to the writ petition indicates that at the time of death of the father of the petitioner was 10 years of age, and the brother of the petitioner was never appointed, as he expired on 30/5/2011 prior to the order of rejection of his candidature on 11/10/2011, and the present writ petition has been filed in the year 2023. In view of the aforesaid facts and circumstances, this court finds that the petitioner is not entitled for compassionate appointment, and no relief as prayed for by the petitioner can be granted. Accordingly, this petition is hereby dismissed. Next. Yes.
Item 8, the rupees 2613 of 2023.
Yes, petitioner.
Challenge in this case is to Annexure 16
Open it
because
here
that
also.
is the
The entire file is open. This is the entire file or only the petition? Yes, what is your case?
Milor's challenge is to Annexure 16 before inviting Milor's to the improved order. Milor's white order dated 28/2/2024 Milor's has stated that Milor's there is a conflicting view of the Milor's division bench. Because the conflicting view of the Honorable Single Judge Milor's by a coordinate bench Milor's. That order is 28/2/24. That order could not be Milor's uploaded Milor's.
It is not there. There is no such order.
It was 28/2/2024 Milor's.
There is no such order. There is no such order. Learned counsel submits that there are
Certain
contrary
orders have been
orders.
passed by a coordinate bench Milor's wherein the emotional benefit has
Yes,
been.
where is that?
Because that has not been uploaded, Milor's. But my respectful submissions for my not kind consideration is to the extent, Milor's, that I am only confining myself, Milor's, to the extension of the benefits, Milor's, for the purpose of calculation of the retirement dues, Milor's. For that, Milor's, the university itself has taken a decision, Milor's, and not only the university, Milor's, the director has also taken a decision, Milor's. And in terms of that, Milor's, decision of the director, Milor's, the retirement benefit should be extended to me. And so far, Milor's, the another coordinate.
Just a moment. Just a
Milor's.
moment.
I am only confining to prayer number C and D, Milor's.
Just a moment. Prayer number C and D, right?
D. And so far the counting of
You
the
come to Annexure 8.
Milor's. Milor's.
What is the page number of Annexure 8?
847 Milor's.
Page 47.
My name is Milor's at the serial
Just a
number.
moment. Page number 40. No, this is running page 47.
It's a tabular chart.
You come to page number 46, Annexure 8 dated 11/4/2014,
Milor's.
right?
Milor's.
You come to paragraph number 1.
Milor's. यह वेतन निर्धारण वैचारिक रूप से 1/1/96 से किया जाता है Milor's, जिसका वित्तीय लाभ अंतरकलन समायोजन की तिथि से देय होगा. विभागीय संख्या so far
You
that
just
part-
hold on.
Milor's.
So, you are, is this particular clause coming in your way?
Milords, it is there, Milords. It is coming in my way.
Okay.
I am not aggrieved by this now, Milords. What I am aggrieved by, Milords, now I am confining only, Milords, that my pensionary dues should be counted from the very date of my initial appointment.
So therefore, how can it be?
Milords, two orders there. University itself has taken a
No,
decision.
university might have taken a decision, but so far as this order dated 11/4/2014
Milords,
is
so
concerned,
salary part I am not pressing, Milords.
all financial benefits.
Milords, salary part I am not pressing, Milords. So for the continuity in service, Milords, may kindly have a glance to Milords, two orders passed by the university as well as the state, Milords.
The state has already decided in your favor.
Yes, Milords, that is what I am saying, Milords.
Then what is your grievance now?
My grievance is only that should be calculated in my favor, whatever has been stated by the state. That is
State.
at page 66.
66. Of the?
Of this Milords petition. Annexure 16, page 65 Milords. It starts, Milords. मेरे बारे में है वो clause 1 में है, जरा से उसको place कर दें.
Yes, please.
Milords got that.
You are not seeking quashing of any
No,
order?
Milords, I am not now. Milords, I am foregoing that prayers. Milords, I am only confining to prayer number C and D, which is in consonance with clause F of this, Milords. Page number 66 पे clause F है with respect to me. 66 पे 2 के just ऊपर में हुजूर को मिल गया. श्री डे की सेवा की गणना इनिशियल डेट ऑफ ज्वाइनिंग 7/1/1980 से गणना करते हुए सेवानिवृत्ति लाभ, एसीपी, एमएसईबी का लाभ प्रावधान किया गया है, परंतु वित्तीय लाभ नियमितीकरण की तिथि से किया जाएगा. So I am seeking, Milords, for the purposes of calculation of my retirement dues, Milords, it has to be reckoned from 7/1/1980, Milords.
The
Now,
period of service.
notional salary would be, Milords, fixed on the date, Milords, on which I have been regularized, and thereafter the computation has to be made. I am
So
only
you want
confining
implementation of this clause
only F.
whatever manner that
whatever
you are
manner.
not concerned.
No, Milords. And
What
one
is
thing
it?
else, Milords. One thing, एक observation. The university, Milords, may kindly have a glance to the order passed by the director also.
No, we are not concerned. It's a state government decision.
And the university has also taken the same decision, Milords.
It is a state government decision.
It's a state government. एक second खाली page, I'll just invite Milords to page 58.
When they have already taken a decision, we have nothing to
The
say. We can only
university-
expedite your
The
claim.
university has also taken a similar decision, Milords. Page 58 एक बार खाली देख लेंगे
For
उधर.
what?
Page 58 of the writ petition, Milords. I'm sorry. Annexure 13. Sorry, Milords, for traveling with the Milords annexures. Page 13, Milords. Page 58. Milords is also on this that mode that is. We understand. Page 58.
You also shift.
Milords, we will also pay. 58, Milords.
When I can shift, you are much younger
Milords.
than me. Yes.
That, Milords, second clause, that he should be paid retirement benefits such as pension, family pension, gratuity granted with the condition that his length of service shall be counted from the initial only for the purpose of calculating of pension and other retirement benefits for his sanctioned vacant post against which the services were. His pension shall be calculated on the basis of the.
Yes.
That is what they have taken a decision.
Yes.
May I draw the attention of this honorable?
No, let us first understand. He is confining his relief only to a parallel नहीं खुलेगा. I want these files to be parallelly opened because I want to see two documents at a time. You get it? Is it possible? On that day we had opened it. Now you have a new person every day. I just can't. I want these two files, the same file, to be opened parallelly, isn't it? Because I want to see two documents at a time. Now I want to see the prayer. I have to get back to the prayer now.
One. Page 7 of this.
This one, I need the petition. देखिए जो आप नहीं कर पाएंगे ना तो बहुत दिक्कत होगी।
Am I not?
Just a moment. You are confining your relief to
C and D. That it has to be. C also to the extent what is mentioned in clause F.
to calculate the salary कैसे हो?
नहीं सैलरी खत्म कर दे रहे हैं उसको.
तो C में तो वही है ना salary.
D में. it will be notionally fixed thereafter upon recalculation that I am foregoing. I am only confining myself that in accordance with clause F.
You see, I will only say that in according to their own decision, clause 1F at page number 66, and that is the decision of the state government, and decision of the university at page 58. This is what you want?
This is what I want.
Yes, Mrs.
My Lord, I will draw the attention of this honorable court to the law decided by the division bench, including.
This decision is contrary to the law decided by the division bench.
Yes, let me point out. This law laid down by this honorable court says that for pensionary benefits and retirement benefits, service of the person appointed has to be counted from the date of regularization and not prior to that. Let me read out para 4. In view of those facts and circumstances, no error has been committed by the learned single judge and no benefit can be granted to the appellant for pensionary benefits.
Where is that judgment?
By reckoning.
You have annexed it.
This is 2018.
You have annexed it.
No, I have brought it for my lord. 2018, volume 3, JBCJ, 90 HC. It says that the pensionary benefits can be calculated only with effect from the date of regularization and not prior to that. This is the order of Honorable Justice D.N. Patel
And what is the tenure of the order of the impugned order?
It is from the date of initial appointment, that is 80 minutes.
This says that it can be only from the date of regularization and not prior to that.
This is in consonance with the.
I will draw the attention to 3 orders of the division bench of this court. That any financial benefit can be given only with effect from the date of election. That is, I am drawing the attention.
The learned counsel for the parties are present. The learned counsel for the petitioner submits that.
One thing else I was indicating, another coordinate bench which is in session of
that.
large number of writ petitions.
We will hear you.
Minutes.
The learned counsel for the petitioner has submitted that he is confining his relief only to prayer number C and D of the writ petition. And he
to
has
the
also,
extent of minutes what is mentioned in clause F.
And to the extent whatever has been mentioned in clause
1F.
1 within bracket F
of
annexure 16 dated 12/1/2023, and he submits that the same also reflects at page number 58 of the decision of the university dated 28/1/2021. The learned counsel for the petitioner submits that the respondents be directed to follow their own decision and calculate the admissible amount to the petitioner. The learned counsel appearing on behalf of the university or the state?
I am for the university.
For the university has opposed the prayer and has submitted that the division bench of this court has decided by a judgment that no financial benefit can be granted to any person prior to the date of regularization.
Including pensionary benefits.
Including pensionary benefits.
Specifically about this.
The learned counsel has also referred to annexure 8 dated 11/4/2014, and as per clause 1, the clause 1 देखिए page 46.
यह वेतन निर्धारण वैचारिक रूप से 98-96 से किया गया है।
तो इस कोर्ट के ऑर्डर को जरा ध्यान रखिए।
नहीं कोर्ट का ऑर्डर, your terms and conditions of appointment we will not see.
जिसका वित्तीय लाभ से
just a moment, please hold on. 11/4/2014.
यह वेतन निर्धारण वैचारिक रूप से 1/1/98 से किया जाता है, जिसका वित्तीय लाभ समायोजन की तिथि से दिया।
हाँ,
from
right?
the date of regularization.
Same thing, whatever you are saying?
Yes.
Okay, we'll see that. The learned counsel has also referred to order dated 11/4/2014 as contained in annexure 8, which is the order regarding regularization, and submits that as per clause 1 thereof, the salary was notionally fixed with effect from 1/1/1998, but all financial benefits was directed to be paid only from the date of regularization. The learned counsel submits that any period of service rendered prior to date of regularization cannot be calculated for the purposes of calculation of post-retirement benefits also.
Salary and post.
That would be in
लग नहीं
violation
रहा
of
है,
rule.
लेकिन आप हमको जरा समझाइए.
That would be in violation of rule 59 of the pension rules, Minos.
So, Mr. Singh, just tell us what is the meaning of Vaicharik रूप से 1/1/1998?
Notional.
Notionally.
Notionally.
If you fix the pay notionally from 1/1/1998, then why the period of service which has been rendered during this period will be excluded for the purposes of calculation of his retirement benefits? If a person is absorbed in service with this kind of a clause and he does not complete 10 years of service, you will not give him pension.
This is what this honorable court has said. I will just draw the attention.
And this clause has been taken into consideration.
No, in this case it has not been taken into consideration, but it says that for pensionary benefits, that period prior to regularization shall not be counted.
The terms and conditions of regularization are not important.
I am only drawing the attention. This is the order
Because
of
rule
my lord.
Rule 59 is very clear,
My
Minos.
lord's
And the
order,
coordinate
I
bench,
brought the
Minos, which is hearing a batch
salary
of.
and post-retirement benefits to be
एक
given.
बार इसको खाली देख लीजिए ना. A batch of writ petitions is being heard by Minos coordinate bench. Clause 7 of this, Minos. Para 7, Minos. I'm sorry. A batch of writ petitions are being heard.
It is pending.
It is pending. Minos.
My lord
This was the
also-
direction of the Minos. The court will further indicate that merely because an order of absorption regularization was not passed by the respondent authority or passed after several years of service, even though the petitioner had worked for decades altogether, was paid salary, the petitioners cannot be deprived of the pension.
There are
Mr.
two
Singh,
orders.
Mr. Singh, on the face of clause number 1 of letter dated 1/11/2014, annexure 8, prima facie the petitioner cannot be deprived of benefit of his past service,
That too for the purposes of Minos pensionary.
irrespective of whatever happens before the division bench, because it is a part of the terms and conditions of regularization.
Let me draw the attention of this court to two orders passed.
You
on
place
this
it.
specific
I will hear you.
issue. I am
You
giving
place
I am giving copy of those orders.
You place it. Do you any counter file?
There is a counter has been filed.
Opposing or supporting?
How can it be Minos opposing?
You are opposing?
Opposing.
Opposing what?
Your Lordship, as per 1F, Your Lordship, clause that from the date of joining Your Lordship, from the date of the initial appointment, Your Lordship, only ACP and MSCP can be calculated. And for the rest of the financial benefits, that will not be.
ACP and MACP you will calculate from 1/1/1998. And for the purposes of giving him pensionary benefit, you will not calculate. What kind of contradictory stand is this?
My lord, in division bench, in the order that I have given before my lord, this honorable court in division bench has said that the period of appointment on unsanctioned post is an illegal appointment, and that period cannot be counted for pensionary benefits. That is the order in the case of Suchitra Jha, LPA 502 of 2022.
That's right. But the point is that when you regularize them, then under such circumstances, why have you put clause 1 there? It is your document. Whose document is
I
that?
am not disputing, only urging this honorable court to peruse these two documents. I have
We
filed.
will see.
Yes.
But on the face of clause, on the face of annexure 8 dated 11/4/2014, you need to support you. Meaning thereby you are taking away clause 1, isn't it? Are you taking away clause 1? Tell us, what does this mean?
यह वेतन निर्धारण 1/1/98 से किया जाएगा वैचारिक रूप से,
हाँ.
जिसका वित्तीय लाभ मिलेगा फ्रॉम द डेट ऑफ
तो 1/1/98 क्यों आप लिखे?
फॉर नोशनली कैलकुलेटिंग द सैलरी बैक सर्विसेज को टू दैट एक्सटेंट ही इज करेक्ट. आई एम टेकिंग इनटू कंसीडरेशन फॉर फिक्सेशन ऑफ सैलरी ऑन द डेट ऑफ रेगुलराइजेशन. बट दिस यस
This clause was under consideration before the division.
No, it was a different case. I am only drawing to submit to my lord. In that case, the question that fell for division bench is whether the period prior to regularization, when the person was serving on an unsanctioned post and thereby his appointment was illegal, can it be counted for pensionary benefits? And this Honorable Court in Suchitra has said no. That period will not be.
Because there the appointment was illegal. Because here, because if I am regularized on the same post, because that is why I was indicating because it was 59.
I am only drawing
We'll
attention.
hear you, we'll hear you.
And because
The learned counsel for the respondents has also relied upon judgment passed by division bench reported in 2014 SCC online JHAR 837 and LPA number 502 of 2022 in support of his contention that the past period cannot be included for the purposes of calculation of his post-retirement benefits.
As well, I will refer to my note 2017, volume 4, JBCJ.
2017
Volume 4, JBCJ.
volume 4 JBCJ
411 HC.
411
HC.
HC.
And one more last.
Yes.
On this very issue.
Yes.
2018, volume 3, JBCJ.
18 volume 3 JBCJ.
90 HC. This is yours.
Sorry, page number?
90 HC.
90 HC. नोट कर लिए दोनों? नोट कर लिए? आप लिख के भी दे दीजिए प्लीज, कोई एरर नहीं.
ठीक.
All these cases are relating to university? No.
No, not.
No, none of the cases are relating
no,
to
one
university.
case is referring to Suchitra Jha is related to that
University.
LPA. That is related
to university.
Otherwise, other cases are not
No,
related.
Suchitra Jha is exclusively of the university.
Because but the
of the
Suchitra
same
Jha's case is
university.
distinguishable in view of the fact because that I was regularized on the same post. Because there, what has happened? Because
We'll take care.
Because
Right? You see, these cases are from the university.
no, because majority of them because not from universities. Also, in few of them universities also. Batch of because 500 cases are almost there. Because, and the general direction was you have to pay in on these counts. Because, and Rule 59 of the Jharkhand pension rules is very clear and categorical to that extent. Because I'll be also arguing on that point. Because let it be
Suchitra Jha is
fixed
from
On
university.
which day?
subject to matters convenience any day.
Pose
Suchitra
this
Jha is
case.
Same university, SK university.
Suchitra Jha is
Let me
from-
just go through it. Pose this case on 10th April 2023. The learned counsel for the parties are directed to file their short synopsis, list of dates and the judgments which they are seeking to rely upon. University has filed a counter.
Yes.
You have filed it?
Yes.
You are opposing or supporting? Opposing. We'll hear it on that day. You file it. Or
Yes,
everything,
I'll
both
file
of you.
all the judgments.
Yes.
Nitish Kumar Day mein nahi file.
नहीं हुआ ऐसे यूनिवर्सिटी है not.
In the meantime, the council for the university shall also seek instructions and file a contract.
My.
Next one.
Item 9, WPS 2709 of 2023.
Anyone, whatever I want. You will be there. You'll be here for some time, don't get nervous, right? Suniye, give him a chair to sit. Sure. Yes. Yes, Mr. Vishnu.
Therefore, grant of compassionate appointment to the petitioner on the post of Anganwadi Sevika. Mother-in-law died in harness on 13/4/2021. 5 years working on the post of Anganwadi Sevika. 13/4/2020. 13/4/2021.
You belong to which category?
Scheduled caste.
SC. What is the majority?
Majority.
BC.
Majority they have mentioned BC. OBC. OBC.
You can't be appointed.
But here is a circular which has to be taken into consideration in view of the fact that the condition which is imposed, because my mother-in-law earlier appointed, even she was SC category, and she during pendency she died. The condition which is imposed is for general selection, general appointment. That condition will not be applied to compassionate appointment.
Where is the scheme?
That is Annexure 8. I have also annexed the circular.
Page number, please.
Annexure 7, Annexure 8, my lord, page 47 to 55. Point number 6 may kindly have. Point number 6.
Any order passed regarding your rejection?
No rejection. They want to know the guideline. This respondent number 5 made written a letter to the respondent number 6 made a written letter to the respondent number 5 asking to seek guideline.
Where is the clause which you are referring to? Clause number?
That is clause number 6. Just a moment.
Kindly read it.
Yes.
कार्य में रहते हुए.
That is page 53.
Yes, I am there. कार्य में रहते हुए. Read it, please.
आंगनवाड़ी सेविका सहायिका के लिए निर्धारित सेवा सर उसके जस्ट नीचे आंगनवाड़ी सेविका सहायिका की कार्य की निवृत्ति सज्जन सर कार्य में रहते हुए मृत्यु होने की स्थिति में आंगनवाड़ी सेविका सहायिका की एक आश्रिता जो चयन की अन्य अर्हता पूर्ण करती हो चयन उक्त आंगनवाड़ी केंद्र के सेविका सहायिका के रूप में किया जाएगा.
That's right. You should be otherwise eligible. Then
Otherwise eligible.
One of the eligibility is that you should be both from the majority community. You see, no, I will not grant you relief whatever you are saying. If you want to pursue your remedy, you can pursue your remedy.
But here, my lord, may kindly see Annexure 7. Annexure 7. They have not rejected my claim.
So therefore, you pursue it. We will not say anything.
So then,
अब यहाँ से चाहिए order तो rejection order मिल सकता है.
In view of Annexure 7, the respondent authority may pass appropriate order because there is a confusion with the letter of this, the spirit of this letter, because they want to get guideline because general condition will not be applicable in a compassionate appointment because it's a general exception. Which leads to condition. The entire notification, the clause number 3 and 5 is for the selection of a fresher candidate, not for the compassionate appointment.
You have filed your counter.
Yes, Your Lordship.
Is there any rejection order?
No.
Your Lordship, but in para 16, my lord, we have stated para 16 of the counter affidavit, my lord, that his case has been considered, my lord, and thereafter found that he is not eligible, my lord. Otherwise criteria, so his case
has been rejected.
Yes.
No such.
Para 16 of the counter, that with regard to the statement made in para 14 to 17 of the petition reply, it is stated that on the basis of the representation submitted by the petitioner before Deputy Commissioner Dumka, learned Deputy Commissioner Dumka directed to look into the matter.
This is Annexure 7 reference. This is not issued by the Deputy Commissioner. Which my learned friend is reading, that is Annexure 7. That is not issue order passed by the respondent number Deputy Commissioner.
Para number?
Para 16, my lord, of the counter.
Para 16.
Why is it not taking full screen?
Para 16 is the narration of Annexure 6, Annexure 7.
It is still half the screen from the bottom.
Again click on that.
Still half the screen. You read para 16, please.
That's with regard to the statement made in para 14 to 17 of the writ petition and the reply, it is stated and submitted that on the basis of the representation submitted by the petitioner before Deputy Commissioner Dumka, learned Deputy Commissioner Dumka directed to look into the matter and send the same to District Social Welfare Officer Dumka, who called for detailed status.
Where is the letter dated 6/1/2023?
Yes, that is annexure 7 of the writ petition.
Page number?
Page 46 of the writ petition.
Page number 40?
6 of the writ petition.
There is no page 46.
Page 46 of the writ petition, annexure 7.
Yes, no. Page 46 of the writ petition. I want the entire file to open. You are not getting it. Whatever I am asking. This is the. Where is the order of rejection? Tell us.
That is not on record, my lord.
Even
But
no reference is
this
made in
letter,
this.
my lord.
This letter I have also pointed out. This letter से इसके चयन हेतु मार्गदर्शन की मांग की जा सकती है.
They are only seeking the
Guideline.
guideline.
Yes, I mean they have said ki
And then you say that it has been rejected.
But
No,
in the
this is
counter,
an
my lord, it has been stated that she is not fulfilling the other criteria, so his case cannot be considered for compassionate ground in the counter. My lord.
You see, if you want a clear order, I am not with you. If you want to pursue your remedy, you pursue your remedy.
But with regard to annexure 7, he may be directed to pass an appropriate order in accordance with law, whatever.
The learned counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the petitioner belongs to scheduled caste category and his mother and her mother-in-law was the Anganwadi Sevika, and while in service, she expired on 13/4/2021. The learned counsel submits that as per the rules applicable to Anganwadi Sevika, there is a clear provision for grant of compassionate appointment. The learned counsel has further referred to annexure 7 of the writ petition to submit that while letter number 4 dated 6/1/2023, the Child Development Project Officer has sought certain clarification with regard to entitlement of the petitioner by writing letter to District
Social
Welfare Officer. The learned counsel submits that no decision has been taken so far. The learned counsel for the respondents, while opposing the prayer, has submitted that in the counter affidavit it has been specifically mentioned that the majority community for which Anganwadi Sevika for the majority community in the present case is BC1 category, and as per the scheme for compassionate appointment, a person is entitled only when is entitled for compassionate appointment only when she satisfies all the eligibility criteria. He has also submitted that.
He has also less marks from the other candidate. Her marks is less.
Candidate, there was a Amsabha conducted.
Amsabha conducted.
You participated?
Yes, I participated. 10 of the candidates have participated. Therefore, I am submitting.
The learned counsel has also.
Selection will not be applicable.
The learned counsel has also submitted that the petitioner had participated in the selection process and obtained less marks. To this, the counsel for the petitioner has submitted that the obtaining of less marks will not be an impediment for grant of compassionate appointment, in view of the fact that for the grant of compassionate appointment, a candidate need not participate in the general selection process. And merely because the petitioner has participated in the general selection process, that will not disentitle the petitioner from claiming compassionate appointment, for which she is otherwise entitled. The learned counsel submits that no order has been passed so far as the claim of compassionate appointment is concerned. Considering the nature of dispute involved in the present case, this court is of the considered view that although the respondents have filed a counter affidavit opposing the prayer of the petitioner for grant of compassionate appointment, but no order as such has been passed in connection with the claim of the petitioner. This court finds that the decision in such a case, in such a matter, is required to be taken by the respondent number 2. Right?
Yes.
As the claim of compassionate appointment is required to be considered in the light of the scheme and the applicable circulars. Right? In view of the aforesaid facts and circumstances, this writ petition is disposed of, enabling the petitioner to approach the respondent number 2 by filing a representation along with a copy of the writ records within a period of 15 days.
Yes.
15 days from today. Upon filing of such representation, the respondent number 2 shall seek the necessary information and data from the respondent number Sariyahat hai ye?
हाँ सर ये
From the other respondents.
Your Lordship, if no such order passed.
Just we'll take care of that. From other respondents, and pass a reasoned order after granting an opportunity of hearing to the petitioner. It is further observed that if any order has already been passed with regard to entitlement of the petitioner, no fresh order need be passed, and a copy of the same be simply forwarded to the petitioner. This writ petition is accordingly disposed of.
Item 10, WPS 2739 of 2023.
Any document I can put, and this document contains everything, entire file.
Yes,
Okay, yes, petitioner. Who is there for the petitioner?
Kindly put on this case list.
इसका फाइल दिखाइए. The scheme is not applicable. Who is there? Who is seeking time?
Municipal corporation. It's for municipal corporation.
Where is the petitioner? The scheme is not applicable. A counter affidavit has been filed. Counter nahi hai iska. This is not the entire file. No, I wanted that smart view wherein I get the entire file, including counter affidavit. There is a smart view over here which gives the entire file including counter affidavit. This, just a moment, this. No, it's not there. Smart. Oh, this is the Fair. Petitioner is absent. You need time. You also need time.
Lordship, state has not filed their counter. We need to file our response. Municipal corporation has filed their counter.
Yes, they say that this is not applicable. You file your counter affidavit. The learned counsel for the petitioner is absent. The learned counsel for the municipal corporation seeks adjournment. The learned counsel for the state is directed to seek instructions and file a counter affidavit in the present case, taking care of the stand taken by the municipal corporation in its counter affidavit. You have got a copy of their counter affidavit? The counter affidavit of the state be filed by 21st March. Rejoinder, if any, by 4th of April. Post this case under the heading for final disposal on 15th of April.
Item 11, WPS 4805 of 2023.
This is the entire file. Yes, Council. What is the relief?
Petitioner pays for
File a counter affidavit. The learned counsel for the parties are present. The learned counsel for the respondents is directed to seek instruction and file a counter affidavit in this case by 20th March. By 21st March, rejoinder if any by 4th of April. Post on, अभी जो timeline क्या दिए थे हम लोग? Same timeline कर दीजिए. The previous case में क्या दिए थे?
4th तक rejoinder का था and final disposal में 15th.
हाँ, 4th rejoinder, final disposal on 15th. They under the heading for admission on 15th, not final disposal.
admission on
15th. Next matter.
You must have date for filing counter affidavit.
Item 12.
Date is 21st of March.
Item 12, WPS 4816 of 2023.
If the claim of the petitioner has been admitted in the counter affidavit, only the financial benefits has to come to the petitioner. They have taken a decision to allow the relief.
The learned counsel for the parties are present. The state petition has been filed for the following relief. The learned counsel for the the petitioner at the outset has submitted that as per the circular issued by the
Office order has also been office order has been issued with respect to these petitions while taking into account the
learned
pendency.
counsel submits that the office order with regard to these petitioners has been annexed along with the counter affidavit.
Annexure 8, that is dated 26/10/2023.
26 by order dated 26/10/2023, but the financial benefit has not been given. 26/8.
10.
10. When was the writ petition filed?
The writ petition was filed once.
The writ petition was filed on
21/8.
21/8/2023. The learned counsel submits that some observation may be made so that the financial benefit is also conferred to the petitioner. The learned counsel for the respondent state has submitted that the financial benefit, if any, arising out of the office order annexed with the counter affidavit can be expedited. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, it appears that the grievance of the petitioner, as per the petitioner, their grievance has been substantially redressed by virtue of the office order annexed with the counter affidavit, but the financial benefit has not been paid. The respondents, who is the respondent? Who
The
will take
DSC will be the competent authority, joint disbursing authority.
the respondent number?
4.
The petitioners are
Assistant teachers, please.
directed to approach the respondent number 4 for the purposes of financial benefit, if any, arising out of the decision office order contained in the counter affidavit. The needful be done by respondent number 4 within a period of 4 weeks from the date of filing of.
Milords as indicated in earlier order. That
Okay,
would
2
be
months.
2 months.
2 months from the date of filing of representation along with the copy of the writ records. The petitioners would give the foundational facts in their representation. That's it.
This is the earlier order passed by my lords.
That's it. It's okay. Done.
Item 13, WPS 5586 of 2023.
Petitioner. Yes, petitioner. Yes. Not today. Counsel for the petitioner seeks adjournment. However, considering the nature of relief, the learned counsel for the state is the respondent. Who is for the state? The learned counsel for the state is directed to seek instructions and file a counter affidavit. The state should, the counsel for the state also should produce a copy of the records relating to the disciplinary proceedings at the time of hearing. Post this case on 30th April 2024. The counter affidavit be filed by 8th April. Rejoinder if any by 22nd April. The parties to also file short synopsis, list of dates and judgments they seek to rely upon latest by 25th of April.
Item 14, WPS 7474 of 2023.
मैं नंबर प्लेयर की मंडे के लिए इसको रख दिया
क्या matter? What is the matter? There is no merit in this case.
for Monday also.
Counsel for the parties are present. Counsel for the petitioner seeks adjournment. From the records of this case, it appears that the petitioner has challenged the order dated 28/9/2023, wherein he has been dismissed from service on account of unauthorized absence. A counter affidavit has been filed in the present case opposing the prayer, inter alia stating that the petitioner also has a past record of unauthorized absence / delay in coming for duty, and the impugned order has been challenged after expiry of more than 10 years. And accordingly, this writ petition does not call for any interference in the impugned order. Post this case under the heading for final disposal on Tuesday.
For admission, item 15, WPS 4886 of 2023.
Petitioner. item number 15. You wait for some more time. Let me just finish this. This Lok Adalat, then defects, and then we'll take up. Yes, call.
For Lok Adalat, item 17, WPS 4784 of 2023.
Yes. Who's for the respondent?
I am for the petition.
What is the date of death?
In the year 2017.
Respondent is not appearing. Then how do we refer it to Lok Adalat? Are you there?
Earlier it was in
Is it a case fit for referring it to Lok Adalat? Earlier also it was referred to Lok Adalat. The settlement failed.
by that time they intended to file counter to it. On that day.
In counter affidavit they have supported you.
They have not filed. We haven't filed the counter affidavit yet.
It can be settled through Lok Adalat.
It may be referred to a regular bench.
Now counter affidavit they have not filed.
Counsel for the parties are present. Counsel for the respondents has opposed, has submitted that this case may not be referred to Lok Adalat and be heard by a regular bench. However, no counter affidavit has been filed in the present case. Since there is an opposition by the respondents, this matter cannot be referred to Lok Adalat at this stage. However, the counter affidavit be filed by (20th March). Rejoinder, if any, by 4th April. For final disposal on 9th of April.
Item 18, WPS 4872 of 2023.
Ma'am, actually, sorry, madam. In serial number 10, my lord, I was on late seat port number 4, my lord.
What happened in serial number 10?
No appearance. I was on legs before port number 4.
So I have not passed any adverse order against you.
Kindly, no appearance.
How does that make a difference?
Actually, party was.
You see, these all are recorded proceedings. It is very difficult to change an order.
Party was here, your lordship. That's why it is.
Party was here. So all the more I cannot change the order because the order has been passed in his presence. I have not passed any adverse order. It doesn't make any difference.
Actually, no appearance. All right, madam.
Yes, can it be referred to Lok Adalat?
Yes, sir.
With the consent of the learned counsel for the parties, let this matter be placed before ensuing Lok Adalat.
From daily list for orders with defect item 2, Conversion 121 of 2019.
From Monday.
मंडे को क्या करना है?
Defect
कोई बात नहीं, आप आराम से 1, 2 साल, 5 साल में डिफेक्ट
100 कोर्ट फीस में जो आप चालान जमा कर रहे हैं उसी को बोल दी हैं करने हैं खाली मंडे कर दीजिए लास्ट में आज ही कर देंगे
earlier also time was granted.
हाँ मैंने सॉरी मैंने मंडे कर देंगे
It has already been. It was restored.
Yes, ma'am.
Restore के बाद फिर टाइम हुआ और फिर आपको टाइम चाहिए.
मुझे मॉर्निंग मंडे में आज ही हम कर देना है कोर्ट फीस वाले में तो
सिर्फ कोर्ट फीस ही देना है.
कोर्ट फीस से देना है.
And what else? What else is to be filed? Learned counsel for the petitioner prays for and is granted time till 20th March 2024 to remove the surviving defects. Preemptory. If the defects are removed within the stipulated time, post this case under appropriate heading on 25th of April. आप जरा देख लीजिएगा ये मेंटेनेबल है कि नहीं.
Lordship, my name will be
Verify that.
my name will be reflected in the call list, Lordship.
Item 3.
Who are you?
I am for the state, Lordship.
So you give your memo. That
Item
is the
3,
procedure.
Criminal Division 1187 of 2019.
In course of death file करिए इसको.
Sorry?
कोर्ट फी 100 रुपीज पर बात है आज फाइल कर दीजिए आज वर्किंग डेज.
ये वाला जो ऑर्डर है ना इधर 5/9/2019 इसका एक कॉपी वो जो अभी जिसमें टाइम दिए हैं उसमें निकाल के रख दीजिए.
इसके पहले
Same order, same preemptory order. There is a preemptory order.
Item 4, Criminal Division 1595 of 2019.
Petitioner absent. And same order.
Item 5, Criminal Division 1598 of 2019.
Same order. Same.
Item 6, Criminal Division 37 of 2020.
Why is it listed for defect.
इसमें petition
क्या फाइल किया?
ऑनलाइन इसमें करना चाह रहे हैं ज्वाइन नहीं किया
Petitioner is absent. Post this case on next Thursday. There is a defect also in this case. In the meantime, the petitioner shall remove the surviving defects.
Item 7, Conversion 135 of 2020.
There is one surviving defect regarding para 2 malats. This is a revision against a conviction in 138 NI Act. During pendency of that, he has moved in criminal miscellaneous petition before this court.
So
I'll have to file a supplementary affidavit.
I don't get it. What do you want to say?
Plus, there is a surviving defect.
Defect regarding what?
At paragraph 2 malats, petitioner has not stated that he has earlier moved in.
What happened in CRMP?
That CRMP has been disposed of.
Saying what?
That order is not with me, malats. It was dismissed.
CRMP number?
It's, I could not take it down, malats. It is there in the file.
What is the case number?
But I don't have that case. That is the reason I have not stated it. An office note is there.
CRMP number 1552 of 18 का status बताइए.
Dismissal withdrawn to second effective.
Counsel for the petitioner praised for same order then.
2 weeks time will be granted.
I am giving you preemptory time enough to remove the surviving defects. Next. The order will be uploaded and you see the order. We have given time till 20 तारीख तक. कब तक दिए कौन का? 28 March तक preemptory order.
Item 8, Conversion 180 of 2020.
Nobody appears for the petitioner. An order dated, filed order dated 28/2/2022 by way of last chance 2 weeks time was granted to file limitation petition. Limitation petition has been filed, but other defects have not been removed. This petition was dismissed अब इसको same preemptory order.
I am appearing on behalf of the state.
Petitioner absent and pass the same preemptory order.
Item 9,
तो
penal vision
जितना भी same
496.
preemptory order होगा ना, वो सारा पंकज को दे दीजिएगा नंबर.
Item 9, penal vision 496 of 2020.
Yes.
And return fees of election 2 and 3. That defect is ignored for the
Defect?
time being.
Why?
On the period of coronavirus. Matter already compromised petition.
Right.
Lordship, we deny this compromise since at the current stage.
Signed the compromise is.
Yes.
After that, they said that they will be paying that amount on such and such date, which has not been paid.
Matter was compromised on the check amount.
You are
5
paid.
lakhs. 2 lakhs already RTGS.
You
and
see,
3 lakhs.
the compromise has two components. One is the amount and the other is the timeline. So you have failed so far as timeline is concerned. Therefore, the compromise stands failed.
I will take instruction. He
No
paid or
instruction is required. You have to argue the case. Now there is a defect.
not. Defect is 9-1. I have to file a type copy of edited page of annexure 2 and 3.
So first, annexure 2 and 3. What is annexure 2 and 3?
This is a complaint.
You have to file type copy of that. You file it.
Within every type.
Same preemptory order.
But IA may be disposed of.
We will not say anything. There is a defect. Let those defects be removed.
Item 10, penal vision 783 of 2020.
And you have filed a petition seeking exemption from surrender. There is a defect regarding filing of surrender certificate. So that IA has to be disposed of. So I am not inclined to grant you the exemption from surrender.
But I will remove the defect.
No, you see there is a direction for filing a surrender certificate,
Yes, yes.
which is also
That is
one
the
of the
other
defects. If you do not file surrender certificate, then without any order on your IA, the case will stand dismissed on account of non-filing of surrender certificate. Then
But I already filed the IA. For
IA.
exemption for surrender.
So you argue on IA because IA cannot be kept pending. You argue. Like, which is yes, what is your IA? What is the reason for seeking exemption from surrender? Compromise. Compromise has failed. What is the ground?
Petitioner is only the guarantor. Land transaction between some other person, he is the guarantor only as a guarantee. He paid the check to the complainant.
We cannot enter into merits of the case while considering your exemption from surrender. Right? Now you say that please be directed to leave to surrender within a specified period during the pendency of the instant appeal. So what is the specified period you are seeking? This is not a petition for exemption. You simply say some specified period. How much time do you need to surrender?
4 weeks. 4 weeks.
Okay. IA number 3914 of 2020 in criminal revision number 496 of 2020. This petition has been filed praying for leave to surrender within specified period during the pendency of the present revision application. The learned counsel for the petitioner submits that 4 weeks time may be granted to surrender. considering the aforesaid submission. Any objection? 4 weeks, let him surrender in 4 weeks. The learned counsel for the opposite party has no objection to the prayer. Accordingly, IA number 3914 of 2020 is disposed of, directing the petitioner to surrender within a period of 4 weeks from today and file a surrender certificate before this court by 10th of April 2024. Prem-tree. If in the meantime, the petitioner shall also remove all the surviving defects, which is also prem-tree.
Item 10, Criminal Division 783 of 2020.
Lordship, actually for not today, Your Lordship, this matter has to be argued by senior counsel. He has to take because the upper death is proposed related.
It's a defective petition, you remove the defects. Is there any IA? Also for the petitioner seeks adjournment. Pose this case on, how much time do you need? 4th April, under the same heading.
Item 11, Criminal Division 31 of 2021.
Yes, petitioner. We are giving you time till 20th of March. That is the same order being passed in all the cases, and it's a prem-tree order.
This one.
20 March. Prem-tree और बाकी जो same order है. Next.
Item 12, Criminal Division 280 of 2021.
Your Lordship, I will putting this matter for removal of the defects.
Same order. You are getting time till 20th of March. Next.
Item 13, Criminal Division 281 of 2021.
In this case, I have filed locatory application for exemption from surrender.
What is the ground?
Last occasion.
Your Lordship says
Last occasion, Lordship, 15/12/2023, Lordship. From the Lordship, after 3 weeks to file the surrender certificate. But,
yes.
But not filed.
And after 3 weeks, file exemption from surrender. On 2 grounds, Your Lordship, I have already paid ₹1 lakh to the respondent opposite party number 2, and Your Lordship, the petitioner is suffering for paralysis. And petitioner is ready to resolve the return the money.
This is NI Act.
NI Act. 3 lakhs, check in question is of 3 lakhs, and the compensation has been awarded to 6 lakhs.
If you deposit the entire amount, then only there is a question of exemption.
And Lordship, I have to seek instruction on
No,
that
you
point.
don't need to seek instruction. We will pass an order appropriately.
Lordship, he is suffering for paralysis. That's why I am paying for some. The petitioner, he himself is seeking for some time to pay the entire amount. That is the only ground, Your Lordship.
Petitioner of CCL worker, Lordship.
Now he is not in service, Your Lordship.
He's not in service.
Lordship,
From where do you say?
Service mein hai.
From where do you say?
Service mein.
From where do you
Already
say
declared?
that he's not? Please hold on. From where do you say that he's not
No,
in
Lordship,
service?
I have not stated. After conviction, Lordship, that's why problem.
देखिए IA number 468 of 2024. The learned counsel for the parties are present. The learned counsel for the petitioner has submitted that the interlocutory application has been filed seeking exemption from surrender. He has submitted that the petitioner had a paralytic attack and the petitioner has already given ₹1 lakh to the complainant out of the total compensation amount of ₹6 lakhs. Counsel for the opposite party has submitted that the petitioner is an employee of Central Coalfields Limited. And is still in employment. The learned counsel has opposed the prayer and has submitted that the exemption be granted if the entire amount is deposited. Right?
Yes.
Considering the aforesaid submission of the learned counsel for the parties and considering the facts and circumstances of this case, IA number 468 of 2024 is allowed subject to deposit of the remaining compensation amount of ₹5 lakhs before the learned Registrar General of this court
Sometime maybe given.
I'll give you time. By 4th of April. If the remaining compensation amount of ₹5 lakhs is not deposited and in the alternative surrender certificate is not filed, this writ petition shall be dismissed, shall be treated to be dismissed without further reference to bench. Nine one has not been removed. What is 9(1)? Surrender certificate.
Yes.
No, 9(1) is something else. There is a difference. In the meantime, the petitioner to remove the survival defect. If the defects are removed, which is also preemptive.
Yes.
If the defects are removed within the time post this case, I have asked you to surrender by 4th or whatever. Let it be placed under appropriate heading on (18th April).
Item 14, Conversion 560 of 2021.
Yes, petitioner. This is also defective. Petitioner is absent on 2/1/24 also when the case was taken up, the petitioner was absent. However, 2 weeks' time was granted to remove the defects. Still, the defects have not been removed. Still, there are surviving defects in the present case.
The prayer is premature.
This petition is accordingly dismissed. This petition is accordingly dismissed.
And my
आप अपने appearance से.
Item 15, criminal division 6 to 6 of 2021.
Joint compromise 5. Who's for opposite party? Mr. Ashadul Haq. Are you there? Opposite party? There has been a compromise. Where is the joint compromise? Where is the joint compromise?
1 week time.
Counsel for the petitioner is absent. Counsel for the opposite party number 2 has submitted that there has been compromise between the parties. 498A.
हम लोग साथ रह रहे हैं क्या कर रहा हम लोग में आपस में कॉम्प्रोमाइज हो गया साथ रह लेकिन पिटीशन तो हम बनाए हुए थे मैंने मुर्सी फाइल किए कि नहीं
However, no joint compromise petition has been filed, although the matter was adjourned for the purpose on 26/4/2023. The counsel for the opposite party submits that 1 week time may be granted. Pose this case on 21st March. Okay. My appearance. You give your appearance. खत्म हो गया?
एक पासवर्ड पे स्टार्टिंग का.
हाँ, एक पासवर्ड है फ्रेश फाइलिंग का, एक केस और. एक बेल मैटर है सीरियल नंबर 17. 16 and 17.
प्रोविजन डेट हम लोग को मिल चुका था हम लोग साथ रह रहे हैं अपने साथ रह के घर बना है एक साथ रह बेबी बॉर्न हुए हैं छोटे बच्चे
कॉम्प्रोमाइज पिटीशन के बिना आपका कितना कहानी हम सुने वो नहीं सुन सकते
हम साथ रह रहे हैं
साथ रह रहे हैं तो
लास्ट लोकेशन
भाई साथ रह रहे वेयर इज द जॉइंट कॉम्प्रोमाइज पिटीशन
Joint compromise already on record.
IL number 8596 of 2022.
8596.
Yes, ma'am.
कहाँ है ये नंबर? 8956 तो हमको कहीं दिखी नहीं.
Serial number 16 में भाई.
16 में.
16 में 3647 है.
8596.
नहीं अब जब रिकॉर्ड देखिए तब तक हम दूसरा केस आप ठीक से रिकॉर्ड देखिए जॉइंट कॉम्प्रोमाइज है तो ऑर्डर करेंगे उसमें आप देखिए रिकॉर्ड हाँ देयर इज वन पासवर्ड देयर आर 3 cases clubbed together right 3 केस है ना
2 cases
16 and 17
16 and 17
18 is for condonation of delay. Yes, how much is the delay?
440. Perhaps I don't have the copy. For last date I have requested for the copy, and I have not submitted this cost, that's why I could not procure the copy. So I'm praying for it may be simply
You could not procure the copy means?
the copy of the brief.
Copy of the brief, you don't, you are the, for the petitioner?
Yes, I'm for the petitioner. I got a law objection after I filed my Wakalatnama.
Yes.
So I don't have the copy of that. Perhaps I have read it, the 443 day, 443 or 445 day is the delay. The order has been passed ex parte. And after knowing that I have challenged here. And on for the last occasion, a report has been called for in this case regarding
50,000 was to be deposited. You have deposited?
No, Your Lordship. The flag R is a report, and the report in last occasion by the order of this honorable court, the report has been called for regarding the competency of the petitioner paying this amount. So the report has been on the record, and he is not competent. He
Not
is,
competent, so you go to jail.
so that's why the case has posted for the hearing.
Hearing means what?
But
I'm hearing you.
no, for final hearing. So that's why I have requested for the giving on my cost a copy may be provided to me, so that I can finally argue on the merits of the case.
When there is an order to,
Yes, sir. Yes, sir.
the interim order stands vacated. What was the interim order?
Interim order was that on the subject of deposit of 50,000 to the in the trial court, I have granted a stay. I have deposited the same thereafter on subsequent date when the case was listed. A report has been called for. Perhaps on that day I was not well, so I was not appearing. So on that date, on the proxy counsel has taken.
You are for the opposite party.
Opposite party, Mr. Vivasan has appeared for the opposite
Where
party.
is he? IA number? What is the IA number? Opposite party appear करते हैं इसमें. Service is complete. They are appearing, no, they have already entered appearance, I think.
He has appeared in last occasion also.
Where is he? No counter affidavit has been filed?
Earlier the case has been gone to Jhalsa for settlement, but it could not settle there.
आपके पास पैसा ही नहीं है तो क्या
जी,
सेटल करेंगे?
पैसा है ही नहीं, वो रिपोर्ट भी आया होगा 2-3 हजार रुपया ही मेरे पास है और आई एम डेली बेसिस पे रिपोर्ट आया हुआ है. The inquiry has been conducted by the superintendent of police by the order of this honorable court. Sir. So I have tendered on last occasion that I am willing to pay 1,500 rupees per month if they so, but the opposite party has refused to take the money per month. To my best.
IA number 5571 of 2022 and criminal revision number 446 of 2020. This petition has been filed for condonation of delay. The learned counsel for the petition has submitted that there has been delay of 447 days in filing the revision application. He has submitted that the impugned order is an ex parte order, and upon coming to know about the impugned order, the present petition has been filed. Any objection? Mr. Vikas, any objection? Counsel for the opposite party number 2 has no serious objection to the prayer for condonation of delay. After going to the petition for condonation of delay and being satisfied with the cause shown, IACR number 5571 of 2022, seeking condonation of delay in filing the present revision application is allowed.
Right.
When will you do this case?
On Monday or Tuesday, I will deposit the fees and then 3 weeks time may be given.
Fees means?
The cost for procuring the copy of the. I have to deposit the cost for taking the petition.
By which order?
by order, last order. Now, I have requested before the court that I don't have the copy. So, on my instance, it has been ordered. I have to deposit. I will deposit on Monday or Tuesday. So, 3 or 4 weeks may be enough for me.
Time granted to the petitioner by the order dated 14/12/2023 to deposit certain amount by way of demand draft has expired.
For the cost for the procuring the petition.
There is no such
But it's
order.
the last order.
The last order passed by Honorable Justice Navneet Kumar.
Order number 9 dated 8th of February 2020. The bottom, para 4 of the order.
You provided the copy.
But I already, but what the has come in the notice is also absolutely printed out. What is with me, I can provide.
Office is directed to provide a soft copy of the entire records of this case, including the records received from the court concerned at the following email ID. इनका जरा mail ID और phone number ले लीजिए और भेज दीजिए. Scanned copy भी दे दीजिएगा records का और पूरा ही record कर दीजिए. You also need it?
Yes, yes, I do.
अपना phone number दीजिए. Post this case under the heading for final disposal on. उस दिन टाइम मत मानिएगा, हम डिसमिस कर देंगे आपका केस on 4th April. पास ओवर है ना?
Also, case from supplementary list item 5, WPS 1006 of 2023.
Second round of litigation.
Yes.
Election rate is 63 is the due order.
ये कौन सा पास ओवर है इससे?
Election rate is 63. This was passed at the
Impugned order.
Not the order which has been challenged.
Where is the challenge to this order?
Election 8 page 63.
No, where is the challenge in the writ petition?
Yes, not.
Let us see that this order is under challenge. This is not under challenge.
Your Ladyship, if I may just indicate the prayer in para 1.
Yes, I've seen it. This is not under challenge.
Implementation of order passed in WPS number 1814 of 2020, page number 2.
Lord,
I have the order which was
it has
passed.
not been challenged, I admit.
So you file a fresh. We do not. That is not under challenge.
Same prayer, Your Ladyship, in that way.
Same prayer.
Same. Three additional increments with
Error, what I found, only IA is required to file for amendment. This is a technical error which my friend is taking defect. That if that has been missed. But they are not taking the even if same prayer I admit there is a typographical error. Or say cut paste what I say. If not say we'll see lecture 8 page 63.
Learned counsel for the parties are present. From the perusal of the records of this, from the perusal of the prayer made in this writ petition, there is no challenge to the order contained in memo number 1603 dated 11/11/2022 within bracket annexure 8. The learned counsel submits that on account of inadvertent error, such prayer has not been made, and the foundational pleading to challenge the same is there on record.
But pleadings are there, but
Where is that? Where is it?
Since if not
Para number, please. That you have challenged it.
There is no such paragraph.
Paragraph 13.
13 is what? Reasoned order, it has been rejected. That is it. This court finds that neither the state order is under challenge, nor there are foundational pleadings in connection with challenge of the state order in this writ petition. Accordingly, no relief as prayed for by the petitioner can be granted. However, liberty is reserved with the petitioner to take steps against the against Annexure 8 as may be permissible under law.
At permission item 15, the rupees 4886 of 2023.
Please argue your case.
First, I want to forward to have prepared one chart with respect to the channels and the stream of education. Direct BTech degree holder and diploma holder. The very first is notes. I'll come to the advertisement, which is at page 40, the essential qualification mentioned in the advertisement.
Page
40.
What is this advertisement dated?
Yes, advertisements.
You have forwarded any note yesterday?
Because the note is improvising every time, so I thought today I'll argue and I'll send a soft copy to the court master whenever, whichever email ID notes after arguments and submissions of other notes.
Parties may use their note in appeal, right? I don't need note now. If you have not forwarded it, that's your problem. Page 40,
yes.
Annexure.
Page 40, Annexure 2.
What is the date? Advertisement number?
Advertisement number
4 of 2023.
Date is not mentioned.
Okay, 4 of 2023.
4 of the.
Page 40 or 441?
40.
40. What is it?
04. Advertisement number is 04 of 2023 and the page number is 40.
That's right.
Yes. Lords, Kandika 6, the first headline. 6 वर्णित पदों का वेतनमान एवं न्यूनतम शैक्षणिक योग्यता निम्नलिखित है. Minimum educational qualification is stated below. On the left hand side, Lords, there are the posts on which Lords the candidate can apply. I am an electrical engineer, Lords. I have applied for column number 4, Kani Abhyanta Vidyut. And Lords, on the right hand side, the extreme right side column, the qualification is mentioned. मान्यता प्राप्त विश्वविद्यालय संस्था से विद्युत में डिप्लोमा. Thereafter, संबंधित शाखा means in the same stream में उच्च तकनीकी योग्यता धारित करने वाले अभ्यर्थी भी आवेदन के पात्र, which has been derived from the rules notes which I have read yesterday.
You come to the rule.
Yes.
Refer to the rule.
Rule of 2015, which was later on amended, and this particular clause has been added. It is at page number.
You show me both the rules.
All the notes. 2015 rule notes.
It has been amended in 2015?
No, the rule came in 2015, amended in 2019 and 20. Notes, the
2015
rule is page 85, annexure 4.
Original.
Yes, notes, original.
85. Okay. What is the date?
Date is 28/9/2015.
28/9/2015.
2015. Yes. The second page of the rule, which is at page number 86, running page number 86.
Yes.
Column number पारा नंबर 5 पात्रता अर्हता का निर्धारण अभ्यर्थी को उम्र गणना में अध्यादेश वर्ष पहले अगस्त 1916 सेकंड वर्ष अभ्यर्थियों को आयोग में आवेदन पत्र जमा होने की अंतिम तिथि तक वांछित शैक्षणिक योग्यता अर्थात संबंधित विषय में डिप्लोमा प्राप्त करना आवश्यक है। Diploma is mandatory. Thereafter, Lords, an amendment came in the year 2019. The amended rule is at page number 95, annexure 5.
What is the date of this?
Date is page 95. Date is 25th October 2019.
Hard copy of page 94 is not there. This is
Amendment.
2019
Yes, please.
amendment. This is 25/10
2019.
2019.
The second page of the rule, which is at page 96, the relevant
Yes.
mention. Page 96. शैक्षणिक युक्ता विधि द्वारा स्थापित केंद्र सरकार द्वारा मान्यता प्राप्त संस्था के प्राप्ति विद्यार्थी तकनीकी द्वारा मान्यता प्राप्त संस्था से सिविल विद्युत यांत्रिक कृषि अथवा संबंधित अभियंत्रण में डिप्लोमा की उपाधि इन फुल स्टॉप उच्च तकनीकी योग्यताधारी भी आवेदन के पात्र होंगे। तो लॉर्ड्स, दिस शुड बी इन द सेम चैनल. Why should it be in the same channel, my lords? Because here there is no mentioning that the direct, they could have mentioned this particular that the direct BTech HLD और engineering degree वाले भी योग्यता के प्राप्त होंगे. If the intent of the legislature or authority would be that कि we want to permit the direct BTech degree holder, then they could have easily written that degree in engineering is also eligible for participation, which they did in for the assistant engineer rule in 2016, which I'll place.
That is later. But if a person is having a BTech degree in the same channel,
yes,
then what is the need to change the rule? Because he, according to you, he will, as it is, be having a diploma.
Yes.
And then only he will do his engineering through that same channel.
Same channel.
So what is the need for amendment?
The minimum here.
Minimum qualification. There is no maximum qualification. Even a scientist in the field can
yes,
apply.
can apply, but the minimum qualification is diploma, which is a cutoff.
That's
we can take it cutoff.
That's
that this has to be.
If your interpretation is taken,
yes,
then under such circumstances, this diploma is to be followed by one engineering.
Yes.
Right? But this is not the import of this rule.
That's what the point which I am making. Minimum is the cutoff. Diploma is there. So any candidate must be having diploma. Other than that, he have the BTech, MTech, PhD, whatever he will.
It is not that.
Because everywhere it is written minimum. Even in the advertisement, न्यूनतम शैक्षणिक योग्यता is diploma, and in the same stream, if the candidate is having the higher qualification, he and she can apply. Here also, my lords, अभियंता उपाधि होनी जरूरी है. उच्च तकनीकी योग्यताधारी भी आवेदन के पात्र होंगे. Why not they have written that the degree holder should also be there? If we see the intention, my lords, the correct intention of this interpretation, and thereafter, my lords, again the 2021 amendment came out, which is at page number 99, 17th November.
Where is that?
Page 99.
2021 amendment. You are governed by this also?
Yes. Because this is the amendment in 2015 itself.
Then what happened to this?
Now, in the next page, the same thing has been recreated. डिप्लोमा में उपाधि second paragraph and उच्च तकनीकी योग्यता धारी भी आवेदन के पात्र होंगे. Thereafter, they have added the न्यूनतम शैक्षणिक योग्यता in the mid clause. The amendment which they are carrying. So they have written न्यूनतम शैक्षणिक the minimum, which is the cut-off qualification. अभ्यर्थियों के लिए उनका आवेदन पत्र झारखंड कर्मचारी चयन आयोग द्वारा विज्ञापित आवेदन जमा करने की अंतिम तिथि तक नियमावली अनुसूचित 1 में पद में न्यूनतम शैक्षणिक योग्यता विधि द्वारा स्थापित केंद्र सरकार द्वारा स्थापित स्वयं तकनीकी योग्यता द्वारा मान्यता प्राप्त संस्था सिविल विद्युत यांत्रिक एवं संबंधित अभियंताओं में डिप्लोमा की उपाधि ने फुल स्टॉप उच्च तकनीकी योग्यता भी आवेदन के पात्र होंगे. Thereafter, अभ्यर्थियों का उनका आवेदन पत्र आयोग में जमा होने की अंतिम तिथि तक नियमावली की अधिसूचना 2 में अंकित पदों के लिए उस पद पर नियुक्ति हेतु गठित नियमावली में पद विशेष के लिए अंकित न्यूनतम शैक्षणिक योग्यता तथा अन्य तकनीकी विशिष्ट योग्यता प्राप्त करना अनिवार्य होगा. That is mandatory. Thereafter, उक्त अनिवार्य योग्यता में अतिरिक्त अभ्यर्थियों पर 10.30 झारखंड राज्य से मान्यता प्राप्त स्वयं होंगे. So here again they have clarified that minimum qualification should be diploma. Along with that, whatever you have the higher.
You just let us know one thing. If this term was not there, उच्च तकनीकी योग्यता धारी भी आवेदन के पात्र होंगे, right? Then a person who is having higher technical qualification and having a diploma, right? Was he disqualified? No. Then what is the big idea of putting it? He was never disqualified. You say that you want metric.
Yes.
And then you just say that BSc will also be eligible. Anybody who is BSc is already metric. Yes. What's the big idea of introducing it?
If the intention would be of the state government, then they could have written the word engineering. Simplicity. Supposedly, I'm putting a question to myself. Supposedly, for the post of A&M nurse, if the doctor starts applying, because they are much qualified, but they are not trained with respect to the nursing. Similarly, with respect to DLED and BEd, DLED for the 1 to 5 students. The Supreme Court has written it that DLED should be 1 to 5 and above that it should be BEd. So if BEd candidate will start applying for 1 to 5 because they are not trained to deal with the children who are 5 to 6 year old. That is a particular course of DL. Similarly, junior engineer is more of the practical knowledge than of the academic knowledge. And that's why this course has brought after 10 3-year course and thereafter 3-year engineering. So that they can get used with the machines and etc. Engineering is more of the academic and the assistant engineer of the management.
You are not answering my question.
Yes.
When the minimum qualification is diploma,
yes,
and you say that diploma is a condition precedent and that is the minimum qualification, what is the purpose of putting this? In absence of this particular last line, are these people disqualified?
No.
No. So what is the purpose of doing it?
So that the confusion with respect.
It's not a clarificatory in nature. It is not clarificatory.
That's what I'm submitting, so that the engineer after diploma who has done, they should not be.
They are not disqualified.
Because
Otherwise also, a person may have n number of qualifications. If you say that diploma is the minimum requirement and that is it, then irrespective of whether he has higher qualification, other qualification, maybe an artist, maybe a dramatist, we do not know. He is not disqualified. You want to interpret it in a manner that he should be diploma and plus higher qualification following a diploma. Not required.
The same channel.
Not required. It doesn't sound to reasons at all.
Because this particular post, I have also challenge this particular clause of the advertisement so far as it contained that the with respect to that this particular uch takniki
Have you
yogta-
participated or you are
Partici-
disqualified?
Participated.
You are not disqualified for any reason.
I am not disqualified.
Then why have you challenged this clause in the writ petition?
Because Lords, the direct BTech degree holder is
You are
they
aggrieved by
entitled-
only that.
only with
Only those people who have direct BTech
BTech
degree
degree.
and they are participating.
They are participating.
That is your only grievance.
Only grievances.
Please don't expand your
No,
grievance.
no. My
Scope of
challenge was
grievance.
also with respect to that particular clause should be interpreted only in the same channel, higher qualification in the same channel. That is my grievance. Not I have directly challenged that particular clause.
That's it.
So this is my interpretation of and followed by judgment notes. One judgment recently yesterday night I have searched note with respect to same. This is Lords yesterday I found out. This is with respect to same particular clause, Uch Takniki Yogta of Rajasthan High Court, which was later on quashed by the Rajasthan High Court. However, I have checked Lords, an appeal has been filed in division bench. It is pending. But I have marked that particular clause, which is at page 8, that यहाँ पे भी मतलब this particular clause also कुछ शैक्षणिक योग्यता will also be correct. And the Rajasthan High Court, after considering the judgments of Supreme Court and other high courts, they have said
We
that
cannot follow a judgment which has
Yes,
not
Lords.
yet attained finality.
yes, not at all, no, only for reference.
That's right.
Only for reference, Lords. My
Pending
argument-
in appeal.
Yes, Lords, because they have itself stated in the downside of the first para. Any judgment is printed out from the Rajasthan High Court. If any appeal is pending, they marked it in the PDF copy.
That's good.
Yeah, that is very nice, which I found out. And
It is still
also
pending?
stated. Yes, Lord.
It is still pending.
Yes, still pending. I've searched.
When did you take a print?
Printed out, Lords. I have searched, Lord. This DB number in the matter is still pending. Just now, I've searched. It is not.
What is the clause here?
Clause is not, Lords, which is at page number 8. This clause was challenged.
Page number 8.
It
Now
has-
clause is at, yes, page number 8. Can you read it?
Yes, Lord. I marked, Lord. उपरोक्त निर्धारित शैक्षणिक योग्यता के संबंध में यह स्पष्ट किया जाता है कि उक्त वर्णित शैक्षणिक योग्यता में उच्चतर शैक्षणिक योग्यता रखने वाले अभ्यर्थी भी मोटर वाहन उप निरीक्षक पद के लिए आवेदन प्राप्त होंगे।
And what was the scope of challenge?
Scope of challenge, Lord, they have the.
What is the prayer?
Yes. Let's start from Lord, page number 6. The issue with respect to direct BTech degree holder and diploma holder itself. This particular order by the board has been passed by which they have included the direct BTech degree holder, and which was later on in light of the judgment of
It came after issuance of advertisement.
yes.
The qualification was changed to 3 years mechanical engineering, automobile engineering diploma or any qualification declared equivalent to the central government or state government. So that was the introduction of a particular
extra qualification.
Extra qualification in the advertisement,
Yes.
which was under challenge, and they had said that it is contrary to this clause of the advertisement.
Yes.
Right.
But the ratio.
But your case is not.
But the ratio which has been considered by this court is Zahur Ahmad Lords, the judgment which I have mentioned in the compilation, which is the latest judgment of Honorable Supreme Court with respect to higher qualification.
Where is it?
Two judgments Lords of Supreme Court Lords in the compilation I have mentioned, and the second.
You
judgment,
place your judgments one by one.
Yes.
You want to place first one?
First one, Lords. First two judgments Lords will suffice my purpose, Lords. First judgment is 2013-15, SCC 557. It was with respect to the other qualification, B.Ed and special B.Ed.
Where is the clause?
This is with respect to B.Ed and special B.Ed.
Where is the
Yes.
clause of that advertisement? Educational qualification.
important in the submissions, para 4, whether the degree of B.Ed special will be considered under B.Ed degree or not. Para 4 is the submissions. And para 6 is the.
We need to rise. We will continue on Monday.
Tuesday, a lot similar matters also posted, one another same issue. Same issue.
We need to rise. We have some.
Yes, please. Tuesday, both the matters can be taken. Same prayer, everything is same. Leadings complete.
What is that number?
Number is 4853 WPS 4853 of 2023. Petitioner's name is Rajesh Lal versus State Authority.
It is posted on Tuesday.
It is posted on Tuesday also.
The learned counsel for the parties are present. Hearing in the present case has commenced. The learned counsel, in the midst of the hearing, it is informed that one similar writ petition being WPS number 4853 of 2023 has been filed and is posted before this bench on Tuesday.
Yes.
Post this case for further hearing on Tuesday. Tuesday को हम लोग कुछ किए हैं क्या? कोई हम लोग डेट वेट फिक्स किए हैं सेकेंड हाफ के लिए? बताइए. To be taken up as first case at the 15th. Let this matter be treated as part of it.
Leadership. I played for a leave. Today the matter was listed at serial number 16. Yesterday also it was listed. We had to file the counter affidavit today itself. It is ready with us. Only leave me kindly. You file, please. Permission is with us. I'll be filing today itself.
Yes, yes. You just ask them. They'll give.
Obligations.
For all these things, you don't need to mention also. If you want to inspect a record, if you want to mention a matter for early hearing outside the list, no date fixed. For this, you don't need my permission.
Much obliged.
It's your right.